Hello, Charles Cowap here again. This is the third of our 4 presentations on blight and its impact on farmland and rural estates, and in this third presentation we're going to deal with farms and blight. I would emphasise that if you've not had a look at parts 1 and part 2, which deal with just what blight is and the procedures which lead up to the successful service of a blight notice, it's really important that you understand that material before having a look at how blight works in respect of farms, because this has some strange nuances of its own. First of all, for farms and blight, the owner-occupier of an agricultural unit, that's the person entitled, you might recall from presentation number 1, must have occupied the whole of the unit, and that includes dwellings and buildings occupied for the purpose of farming. So the first snag that you might encounter when dealing with blight on the farm is if the owner-occupier of the agricultural unit has sublet parts of it, granted licenses over part of the unit, and whatever. Section 158 of the 1990 Planning Act deals with affected areas and unaffected areas on farms. In the second presentation we saw the effect of the material detriment test, which arises under the Compulsory Purchase Act. That test applies to houses and manufactories and gardens and those sorts of things, but it does not apply to farms. Farms have their own provisions, which we're going to look at now. And to serve a blight notice, as we saw in section 2, on the whole of a farm, where typically only part is required, to have that blight notice accepted for the whole of the farm, it must be demonstrated that the unaffected area of the farm cannot reasonably be farmed. That's a really stiff and strict test. Nevertheless, there is no choice but to serve your blight notice on the whole of the farm to the relevant authority. If it is a relatively small area of the farm that is being required, it is very likely that you will get a counter notice from the relevant authority within the time limits that we discussed in presentation number 2, saying that the unaffected area is not required for the authority scheme. Your option then, as the farmer or the farmer's advisor, is then to serve a notice of reference to the Upper Tribunal Lands Chamber and to argue the case out there. The Upper Tribunal will in particular be looking at section 158 and the consequential provisions, and indeed the small number of cases that have gone to the previous Lands Tribunal on this vexed question. This test then of whether land is reasonably capable of being farmed is very much a physical, not an economic test. The case of Johnson & Johnson and North Yorkshire was one of the first cases to establish here. Not only that, but the unaffected area is considered with what's called in the legislation other relevant land. That's land which is in the same agricultural unit, and it also includes any land in another agricultural unit of which the claimant is also the owner. Owner for this purpose means most obviously the freeholder, but it also means a lease which has got more than 3 years to run on it. And as I've said, this is a physical, not an economic test. Can you physically get to the land? Can you physically work it to either grow an arable crop there or to graze it? It is therefore a very demanding test, and the most likely areas of land which will pass the requirements of the test are those perhaps where access has become virtually impossible as a result of the relevant authorities' development proposals. That's not the end of it, though. What does count as an agricultural unit for these purposes? This is the definition from the legislation. It's land which is occupied as a unit for agricultural purposes. You might think that's a little self-serving, but it does go on to include any dwelling house or other buildings occupied by the same person for the purpose of farming the land. So that's just what an agricultural unit is. So if we find ourselves having to deal with the question of blight on a farm, first of all, can we establish that the land is indeed blighted? We saw what blight was in the first of our 4 presentations. Have reasonable efforts to sell been made, or is it so late in the process because CPOs have been confirmed that that's not necessary? Then it's necessary to identify the affected and the unaffected areas of land. Having done that, we then need to identify the extent of the agricultural unit and any other agricultural units that the same farmer has control of in accordance with the definitions we've seen a moment ago. Then we must form a view on whether the unaffected land is incapable of reasonably being farmed, and that's with regard to other relevant land in the same agricultural unit or another one where the same farmer has an owner's interest. Having got this far, we then serve a blight notice in respect of the whole of the agricultural unit that we have identified. Having done that, we wait for up to 2 months to see if we get a counter notice. If we do get a counter notice, having considered the grounds of it, we refer the whole thing to the upper tribunal within 2 further months from receiving the counter notice. The upper tribunal lands chamber will then confirm the whole or part of the blight notice, depending on whether the unaffected land is or is not reasonably capable of being farmed. If we get this far successfully, we can then claim compensation on the basis of the deemed notice to treat, which follows the confirmation or acceptance of a blight notice. Compensation in farm claims follows the normal headings, so the market value of land taken, severance and injurious affection if only part of the farm is being acquired, disturbance compensation for all the costs of removal, related trading losses and so on, and the basic and occupier loss payments which are due to farmers as well. There'll also potentially be a home loss payment if there's a house involved on the farm as well. However, there's a sting in the tail which might be the final point why you may wish to refrain from serving a blight notice in respect of a farm. Because the compensation for the unaffected land where that is to be acquired under a confirmed blight notice is limited to its existing use value. In other words, its agricultural value, ignoring potential development value, for example. That alone may mean that you won't be very encouraged to serve a blight notice in respect of a farm. So, an additional degree of complexity for blight in farm claims, but I hope these slides have made fairly clear what route has to be taken through those. That was the third of our 4 classes on blight and its impact on farmland and rural estates. In the next class, we're going to go on to look at discretionary blight and give a little update on where the HS2 blight provisions are up to at this time. Again, thank you for your attention. I hope you found this a useful summary of the blight provisions.